In several other lessons, we mentioned the discharge of a party's obligations on an instrument. In this lesson, we'll expand on the concept of discharge and its effect under Article 3. The term discharge refers to the release or satisfaction of an obligation on a negotiable instrument. Under Article 3, a party's obligation on an instrument is discharged to the extent specified in Article 3 itself, or by any act or agreement that would discharge a monetary obligation under an ordinary contract. Article 3 provides several ways by which an obligor is discharged from liability, including, but not limited to, payment, tender of payment, cancellation, and renunciation. We've already discussed discharge by payment and tender of payment in an earlier lesson, so now let's consider discharge by cancellation or renunciation. A person entitled to enforce an instrument may at any time, and with or without consideration, discharge an obligor's liability to pay the instrument by cancellation or renunciation. Imagine that a law student went to a local store in search of a new backpack. After finding the perfect bag, the law student wrote a check payable to the store and handed it to the store's owner. The owner, a rather eccentric man, remarked that the law student reminded him of his son and couldn't accept payment for the bag. The owner then proceeded to take out a tin of tobacco leaves, fill the check, roll it, and smoke it. Was the law student's obligation to pay the check discharged? Yes. In this case, the store owner discharged the law student's obligation through cancellation. Cancellation means discharging an obligation on an instrument by an intentional, voluntary act. Acts of cancellation include surrendering the instrument to the obligor, destroying the instrument, adding a large X across the instrument's face, and cutting out or erasing some essential portion of the instrument.